The Fall 2020 Hinkle, Pryor, and Fisher Parent Empowerment Conference. Realities for a New Reality. 2 days, 25 workshops, renowned speakers and presenters, by families, for families, nearly 40 hours of unfiltered and straightforward information, made possible by the leaders in disability rights advocacy for over 45 years, Hinkle, Pryor, and Fisher, attorneys at law. So welcome to this session of our ongoing encore presentation series of the Fall 2020 Hinkle, Pryor, and Fisher Parent Empowerment Conference.
All right. Good morning, everyone. Welcome and thank you for attending the Hinkle, Pryor, and Fisher Virtual Parent Empowerment Conference. My name is Christina Tosti, and I will be your moderator for the workshop entitled Voting Rights for People with Disabilities, More Important Now Than Ever. Our presenter for this session is Paul Pryor. Before we begin, we ask all participants to remain muted throughout this session. This workshop will last approximately 1 hour, and if time allows, the presenter will take questions either intermittently or at the end. Please ask your questions through the chat feature in the control bar, and I will ask as many of them as I can, again, time permitting. If you have not already done so, I highly encourage you to sign up for this evening's keynote address delivered by former New Jersey's Supreme Court Justice Helen E. Hones, entitled Autism After COVID-19, Navigating a World Where Everything Changed and Nothing Changed. Justice Hones is also the parent of an adult child with autism and will provide a unique perspective on the times in which we live. She's both an inspiring person and inspirational public speaker. You won't want to miss out. Simply go to the conference event page, click on the agenda tab, scroll down to the keynote, and sign up. It is now my pleasure to welcome our presenter. Paul Pryor has spent his entire legal career representing people with disabilities. As a younger brother of a man with autism, he has a lifelong commitment to disability law. His legal work has focused on special education, guardianship, financial entitlements, and access to appropriate services. A substantial part of his practice is devoted to assisting families. He has successfully argued leading cases before the New Jersey Supreme Court, Third Circuit Court of Appeals, as well as other state and federal courts. He served as a federal monitor overseeing conditions at state-operated institutions. He holds a JD from Seton Hall University School of Law and serves on the Board of Trustees of the Arc of New Jersey, as well as Eden Autism. He's a member of the Aspen Professional Advisory Board. Previously served on the boards of Special Olympics New Jersey, Autism New Jersey, and the Eden Autism Foundation Advisory Committee. He's a member of the Elder Law section of New Jersey Bar Association. He's testified before the New Jersey Assembly by invitation, and he's assisted in the development of several pieces of legislation concerning individuals with disabilities. He writes and lectures frequently on topics concerning the law of disability, as well as issues affecting siblings. Paul enjoys listening to live music, running, skiing, and is an avid baseball fan. Now, without further ado, I'm turning it over to you, Paul.
Thanks. Thanks, Christina. Yes, an avid baseball fan. That's really the, I forgot that was part of that. I need to go back and look at that bio again. I think we need to shorten some things up. Anyway, good morning, everybody. Welcome to the Virtual Parent Empowerment Conference. Yes, I am Paul Pryor from Hinkle, Pryor, and Fisher, and thanks for joining us today. We're talking about voting rights. You know, it obviously is a really important topic right about now. Certainly a very timely topic, and certainly something that's been on everyone's mind for a long time. You know, and I don't know if we're going to go the full 90 minutes. I don't know if there's enough content to go the full 90 minutes, but you know, obviously we'll be here to answer questions and you know to field concerns from everybody. Just ask your questions in the chat box, and Christina will feed them to me as we go along. I'll probably take little breaks here and there. So again, as Christina mentioned, you know, you may want to really go back if you haven't already done so and sign up for tonight's keynote address with Justice Helen Hones. You know, when you talk about voting and elections and, you know, a lot of the controversy that, that arises now out of the United States Supreme Court with nominations, you know, elections, as they say, do have consequences, and voting is really important, and letting your preferences be known is really important, because it really affects things more than just who occupies one branch of government or the other. You know, the courts are deeply affected based on the outcome of elections, and, you know, especially Supreme Courts, whether they're state Supreme Courts or United States Supreme Courts. You know, and Justice Holmes is someone that has a lot of insight on that topic, having served on the New Jersey Supreme Court for a number of years. So, but anyway, let's talk about voting. All right. So, I mean, let's before we get started, let's lay down some widely held thoughts or beliefs, you know, almost some ground rules or tent poles when we talk about voting. So first of all, I mean, some of these things probably, I'm going to say, should be fairly self-evident, but, you know, it's worth saying or repeating again. Remember, guys, voting is a fundamental right. It is considered, and when I say fundamental right, that is not a hyperbolic statement. That is not a, you know, poetic statement. That is not a persuasive statement. When we talk about in the law fundamental rights, that is actually a legal term of art. Right? There are certain fundamental rights guaranteed to all people in the United States, and there is only a limited number of fundamental rights. Fundamental rights are things that are specifically enumerated in the United States Constitution, or that have been carved out by the United States Supreme Court. So fundamental rights are different kinds of rights than other rights that, you know, are conferred to citizens of the United States. And fundamental rights can only be deprived, or can only be taken away, or can only be reduced by a court upon the showing of a very, very high standard. It's very difficult to take fundamental rights away from people. And as I said before, there's only a limited number of enumerated fundamental rights. And I used to know them all. I had to know them all when I took the bar exam, you know, 25 years ago. But, you know, many of them are still come to the top of my mind. Voting is obviously one of them. Your First Amendment rights, the right to practice your own religion, the government's inability to establish religion, freedom of speech, freedom of peaceful assembly, and so forth and so on. Those are considered fundamental rights. Marriage is considered a fundamental right. You know, some other, you know, in some circles, you know, hot button or controversial rights that are still considered fundamental are things like contraception, abortion, procreation. The United States Supreme Court has carved those out as being fundamental rights. And it's often considered by the courts that the most fundamental right of all the other fundamental rights is the right to vote. So when we talk about being fundamental, it is a genuine legal term of art. And so let's also lay out some other, what should be given concepts that aren't always accepted in all circles. So for instance, people with disabilities have the right to vote, period. People with intellectual and developmental disabilities have the right to vote. People with mental illness have the right to vote. And sometimes becomes surprising to some individuals, but it's important to recognize that at least in New Jersey, people under guardianship have the right to vote. So don't take for granted that because your son or daughter may have an intellectual and developmental disability, may be living with mental illness, may be under guardianship, that they have been stripped of their right to vote. That's simply not true. The only time that is true is if a court specifically says that you or the person with special needs does not have the right to vote. Right? It's got to say so in the order for guardianship. It's got to specifically state in unequivocal language that the person's right to vote has been taken away. Okay, so those are really some very fundamental concepts, some basic concepts that I think parents need to understand, family members need to understand, and people with disabilities themselves need to be aware of, so that they are able to exercise the right to vote if they so choose. Right? Not everyone wants to vote. Not everybody has, not everybody chooses to vote. Everybody should vote, but you know, just because you have the right to vote doesn't mean you do it all the time, although you should. So, however, there are some people out there that haven't received the memo yet, particularly when it comes to people with intellectual developmental disabilities and people under guardianship. And that includes sometimes people at boards of elections, people at polling places, you know, and just the general public. So let's talk a little bit about this topic in a little bit more detail. I'm not going to bore you. This isn't a law school class. I'm not a law school professor. I'm not ever going to be a law school professor. Don't want to be a law school professor, but it's worth kind of going through some of the history of this and a little bit of some of the cases that are controlling in New Jersey. And by the way, I think it's fair to say that New Jersey is one of the leading states when it comes to voting rights for people with disabilities. There's two really important cases that have been decided by our courts. And then a few years ago, there was some changes to the New Jersey Constitution, which I'll talk about in a second. So let's go all the way back in time. Let's get way back, get in our way back in the machine and go all the way back to 1974. And we have a situation where in a small South Jersey town, several residents of what was known at that time as the New Lisbon State School, now known as the New Lisbon Developmental Center, which is a state-operated institution. Several individuals from that state-operated facility went to the clerk's office, the municipal clerk's office, to register to vote. I was looking at the case in preparation, you know, for this, and I noticed that they went to go register with the town clerk on October 3rd, 1974. That's 46 years ago tomorrow, okay? And there's still people out there that haven't quite grasped the concept of this case, okay? So 46 years ago tomorrow, what was described by the clerk of the municipality, a quote, busload of people from the institution came to the office and tried to vote, or tried to register to vote, excuse me. And they were turned away. The clerk of the municipality said, you cannot register to vote because you are not residents of the town in which you live, in which the institution sits. You are also not eligible to vote because you are an idiot or you are insane, right? Back in the 1970s, the law of the state of New Jersey and the New Jersey Constitution said that no one shall enjoy the right to vote if they are determined to be an idiot or an insane person, right? They were excluded from the right to vote. And this clerk said, just, you know, because you live at the new and receiving services at the New Lisbon State School, you have to, by definition, be an idiot. Okay. Now the law at the time, you have to understand, these terms were in the law in the 1970s. They arise out of the revisions to the state laws and the state constitution that occurred in 1947. And a lot of this language was lifted straight out of the Constitution and the laws of the state of New Jersey that was drafted just after the end of the United States Civil War. You know, 1888, 1887 or somewhere was the previous state constitution and body of law. So the language was lifted right out of that body of law into the 1947 law that carried over into the 1974, you know, circumstance that we find ourselves in. The only problem is that, all right, so you don't have, you have a situation where people who are declared idiots or insane can't vote, but the law never defined what that meant. Like there was no definition of what it meant. There's no definition of what it meant to be an idiot or to be insane. Now, I don't know, you know, and I don't know how you define that today, but I don't know if people, you know, here today watched the presidential debate that occurred this past Tuesday, but, you know, you might have some good examples of idiots and insane people, you know, who participate in that debate. And those are folks running for president, not much less people who are trying to vote for folks in public office. So, you know, those terms are obviously antiquated and arcane terms, but this clerk at the time used this as a way to prevent people in a state-operated institution from voting. So the thing that, and the appellate division of the courts in New Jersey on appeal, in the middle 1970s, you know, this case was litigated and was taken up on appeal to the New Jersey Superior Court in the appellate division. A very young lawyer by the name of Herb Hinkle handled this case. You know, our founding partner handled this case on behalf of these residents at New Lisbon Developmental Center. And the arguments were on two grounds. One, they weren't, as I said, they were residents of the town in which they tried to register. And two, they were not qualified to vote because they were, quote, idiots. So let's talk about some of those issues. The court said that just because, now this is in 1970, the decision came down in 1975, just because you're receiving services in a state-operated institution doesn't make you an idiot, right? You can't be discriminated against because you're receiving services in a state-operated facility. Now, fast forward to today and the issues that what that calls for today. There are still state-operated institutions today. New Lisbon Developmental Center still exists today, right? Back in the 1970s, there was 8 or 9 different state-operated institutions. Now there's only about 3 or 4, you know, providing services to individuals with developmental disabilities. But New Lisbon is still one of them. Just because your kid is in a state-operated facility doesn't mean he can't vote. Just because your daughter is living in a group home doesn't mean she can't vote. Just because your person is receiving services in a supervised apartment and has staff that supports him or her doesn't mean that your child or your loved one can't vote. Just because your kid is classified as being eligible for special education related services doesn't mean your child can't vote. The only requirement is that the child is 18 and is a citizen of the United States. So don't let somebody tell you just because your kid is in special ed, just because your kid is enrolled in DDD, just because your kid is on SSI, they can't vote. The court in this case from 1975 said because you're receiving services is not indicative in any way of your ability to exercise the franchise. The court went on to say that there has to be a specific showing that you are incompetent or incapacitated to vote. Now that, we'll talk about what that means in a minute, and we'll talk about how that's changed over time as well. So at the time in the mid-1970s, what that really meant is that if a person was under guardianship, they retained the right to, they did not have the right to vote. There had to be a specific showing of incompetency or incapacity, and that would only be done in the 1970s through the process of a guardianship. So also, residency becomes an important factor in this case as well. Remember, the clerk said you're not residents of the township, you're just residents of the institution, and therefore you can't vote. The only problem with that is the clerk hadn't received the memo about residency requirements from the New Jersey Supreme Court that came down a few years before that, meaning the case that came down a few years before that, that dealt with the fact that students at college could register to vote in the town in which the college was set. So in the early 1970s, I'm going to say about 1971, 72, remember, this is Watergate era, this is Vietnam era, this is, young adults pushing the envelope a little bit and, trying to exercise their rights in a lot of different ways. The New Jersey Supreme Court came down with the case and said, it arose right out of Mercer County that kids that attended what was then known as Trenton State College or Rider College, they could register to vote in the town in which the college was set, and they were considered residents of that town. They didn't have to go and vote in the town in which they came from. They could register in Ewing Township, where Trenton State College sits, or Lawrence Township, where Rider sits, and exercise the right to vote there. So just because your kid lives in a group home that may be away from where your home is, or away from where he grew up, or lives in a supervised apartment in the next county over, or whatever, it doesn't mean that that person has to still go back and vote in the town which you live. Just because you're the guardian doesn't mean that they have to register and vote in your town. They can vote in the town or the county in which they're currently residing. So don't let people tell you, and there are still people out there that don't get this concept, people in authority that still don't get this concept. Folks can register and vote in the town in which they consider themselves to be home and themselves to have a home. So, and that includes the college kid, that includes the kid living in a group home or wherever. So we have this case that came out in 1974 that should have largely settled this issue. But, however, let's fast forward. Let's get in our time machine and let's go from 1974, 75, and let's move into 1998. And on November 3rd, 1998, there was a young lawyer sitting one evening on election day duty, a young lawyer who was 27 years old, had been out of law school less than 2 years, sitting in the Mercer County Board of Elections office for persons with disabilities. He was a nice guy too, really handsome man, had beautiful blonde hair back then. He was a really good guy. And he's sitting there one night, and the lawyer for the Mercer County Republican Committee delivers a letter to the County Board of Elections saying, essentially, and I'm paraphrasing from memory, that there is a concerted and organized effort to register people to vote and collect absentee ballots from people who are residents at Trenton Psychiatric Hospital. And we, the Republican Party, wish to challenge those absentee ballots, and we wish to challenge those people's right to vote. Okay. And of course, that young lawyer was me. I did have hair. It was blonde. It was full. It was good. I don't know what happened. Maybe I pulled some of my hair out that day. But I'm sitting there, and the lawyer for the Republican Party comes in and delivers this letter and challenges these absentee ballots. Now, before you guys go out there and say, see, it's those Republicans again. I want to make this as nonpartisan as possible. See, it's these Republicans again. They're always trying to do this and that. Before you go too far, shortly thereafter, the lawyer for the Mercer County Democratic Party came along and joined in and supported the challenge by the Republican Party. So there you have it. Remember the good old days where you had, bipartisan support and, working on both sides of the aisle for voter suppression. Okay. So, so they joined in this effort together to strike these ballots being cast. And their argument was, now, in all fairness, the lawyer for the Democratic Party sort of let the lawyer for the Republican Party take the lead. And their essential argument was that the people who live at Trenton Psychiatric Hospital are, in fact, insane and therefore don't have the right to vote. And I remember sitting there at the Board of Elections office listening to the Republican Party's lawyer saying, they're crazy. They're lunatics. They're locked up in a psychiatric hospital. They're insane. Of course they can't vote. Why would you let these people vote? That was the fundamental crux of the argument. The Board of Elections, and by the way, I'd be okay, just as a commentary as aside, I'd be okay if only people who were in psychiatric hospitals and only people who were considered insane had the right to vote, to the exclusion of the rest of us, because I'm not sure the quality of the elected officials would be any different. And I've been saying this for 20 years away. So, just keep that in mind. So an appeal happens at the Board of Elections. The Board of Elections consists of 2 Republicans, 2 Democrats. Believe it or not, the Board of Elections became deadlocked on the issue. So because the 2 Republicans voted to exclude the ballots, the 2 Democratic members of the board voted to let the ballots come through and be counted. So because it was deadlocked, it had to get punted over to a judge. So I remember getting in the back of a squad car and being escorted over by the state police at like 9 o'clock at night to go over to the courthouse to make an argument about why these votes should be counted and why these guys had a right to vote. And the judge the judge decided in his infinite wisdom that he was going to punt, and he said he wasn't going to let the votes be counted. He wasn't going to say that they shouldn't be counted. Basically, he said they had to be segregated and they could only be opened and only be counted if it was going to affect the outcome of the election. Right? It was 5 votes, guys. I mean, that had to be a pretty tight election. So it had this effect of excluding their right to vote. All right. So then this young lawyer, whippersnapper of a lawyer, decides, "Oh, what the hell? Let's take it up on appeal and let's, have some fun." And we took it up on appeal, and the appellate division said again that people who are in state-operated institutions, even if they're insane, enjoy the right to vote. That the challenger, and this is the important part of the case, that the person challenging the ability or the qualifications of the person's right to vote or ability to vote bears the burden of proof by what we call clear and convincing evidence. That's a very high legal standard. What that means is someone goes in and challenges your right or your child's right to cast a ballot vote, they have to prove that your child or you, if you're the person who's with a disability, doesn't have the ability to vote, isn't qualified to vote. They have to bring evidence. They have to show, medical or documentary evidence why you should not be able to vote. And it's got to be a lot of evidence, and it's got to be a very high standard. It's not enough, as the appellate division said in this case, that to simply assert because someone might have a mental illness that they can't vote and they don't understand the electoral process. It's not enough to exclude their right to vote, that you as the person challenging have to demonstrate why. And it's got to be very persuasive evidence and arguments to the contrary. And that's true when we talk about a lot of rights for persons with disabilities. If someone's trying to take your kid's right away, they generally, no matter what the issue is, whether it's voting or other issues, they have to bear the burden of proof to demonstrate that they can't exercise that right. So what happens a lot of times is a practical reality. As someone goes into the polling place to vote, and they may have a, quote, obvious disability, they might have, physical or behavioral features that clearly make it very obvious that they have some sort of an intellectual or cognitive or behaviorally based disability. And sometimes you'll get poll workers or you'll get people that are there to challenge, and they'll come along and say, he can't vote or she can't vote, And I have heard this. I'm going to say something that I don't mean to be offensive, but it was at one time, a term of art, both medically and legally. They'll literally say, even in 2020, that person's retarded. They can't vote, right? They don't understand. So you have to be prepared to know what your rights are, know what your child's rights are, if you're confronted with that situation. So the court in my case basically said, you got to show by clear and convincing evidence. You have to be allowed to vote. Your vote can't be segregated. It can't be, set aside. It can't be, your ballot can't be cast as a second-class ballot. All right. So, it was a nice case. It reaffirmed, the first case that Herb handled a number of years ago, kind of extended it a little bit because it put the burden on the challenger. What I tried to do in that case is I tried to get the court, and I was not successful in this part of it. It was a little bit of a reach at the time, at least. I tried to get the court to say that people under guardianship should still have the right to vote. And I remember, when you argue a case in the appellate division and appellate level courts, you get a whole bunch of judges that sit in front of you. In this case, it was 3 judges that all hammer you with questions. And I remember, a judge pointedly asked me, are you saying that a person who's declared incapacitated should have the right to vote? I said, absolutely, Judge. Again, what was I, 28 years old at the time? Absolutely. And the judge does one of these. Rolls. That's never a good sign when you're a lawyer, by the way. It's never a good feeling when that happens to you. And the judge gives this giant eye roll and head roll. We won anyway, but the court chose not to address that issue. Now, let's fast forward to 2007. Okay, now we're coming into a little bit different time. And through a lot of effort from disability advocates, in particular, the ARC of New Jersey, which I was a member of the board of directors of at the time and still am, some efforts by our office and other disability advocates around the state. We got the legislature and we got the voters of the state of New Jersey to actually amend the state constitution, to remove the language in the state constitution that says that no person who is an idiot or insane shall be deprived the right to vote. All right. And now the Constitution says, and I'm going to read from it, it says, no person who has been adjudicated by a court of competent jurisdiction to lack the capacity to understand the act of voting shall enjoy the right of suffrage. Again, it's written like a constitution. Who uses the word suffrage in their ordinary language? What that means is that unless a court specifically takes away your right to vote, you have the right to vote. The presumption is you have it. The presumption is not that you don't have it. So unless a court specifically takes it away, you have that exercise. You have that right to exercise your right of suffrage, your right of the franchise, your right to vote. So don't let anybody tell you that idiots, imbeciles, morons, and the insane don't have the right to vote, because it's just simply not true. You can refer them to our state's constitution if they have a problem. Now, so that's sort of the legalities. I'm going to get into some practicalities here in a minute, but while I have a second, I'm going to let my vocal cords rest for a moment. Christina, do we have any questions from anybody yet?
We do not have any questions. No, I don't see any questions in the chat feature.
Well, either I'm boring everyone to death, or I'm explaining things completely clearly, and people are wrapped around every word I have to say, and I'm going to choose to go with the latter as opposed to the former. Okay, so all right, so let's talk about some practicalities here for a minute. Let's talk about this year's election and how things are going to be a little bit different in New Jersey. So what you need to know about voting this year, and some of this is going to translate into voting in the future. There are certain deadlines that you need to understand. One of which, and the most important one, is right around the corner. And if you intend to vote in this November's election, on November 3rd, you need to make sure that you're registered to vote. Okay? And the voter registration deadline is October 13th. So it's really important to remember that. October 13th, 21 days prior for the election. Okay, so make sure that if you haven't done so, you get registered to vote. Frankly, my general advice to families at this stage of the game, if you haven't registered to vote but would like to register to vote, that you do so in person at your county board of elections office. Now, they are open. You do have to call ahead, and you will have to, wear masks and all the rest of that stuff. But you want to make sure that you register to vote. You can still fill out the card, you can register online and all the rest of that stuff and submit. But it's important that if you're going to vote and you haven't registered, to go ahead and register. Now, if you're not sure if you are registered to vote, you can do so. You can check out whether you're registered to vote by going to, that isn't it. That's not where you go. There we go. You can go to the New Jersey Division of Elections website, which is www.voter.sbrs.nj.gov/registration. And it will take you to this page where you can put your name in and your date of birth in, hit search, and see if you show up on the voter rolls. Okay, really good idea to do it. It's actually really a good idea, whether or not you're a person with a disability or not, to go ahead and just double check that you are registered to vote. So this year, as many of you probably know, voting in New Jersey, at least, is presumptively by mail-in ballot. Some of you may have already received your mail-in ballots. I know I got mine. I've actually already voted. I voted on Monday. I dropped my ballot in the mail on Monday, and I'm done. So you have the county boards of elections have until October 5th to mail out mail-in ballots to all voters who are on the rolls. So, so if you haven't received it by, the 7th, 8th or so, you need to be a little bit concerned. If you haven't received your mail-in ballot, you can contact your county board of elections and know that you have not received a paper mail-in ballot, that you'd like one, and verify again that they have the right address, that they have they have you on the voter registration rolls at all, etc. And we'll talk in a second how you deal with that if they don't have you on the rolls. So now the ballot's going to come. There is no in-person voting presumptively in New Jersey this year. Okay, so you're going to get your mail-in ballot, you're going to fill it out, you're going to put it back in the envelope, and you're going to drop it back in the mail. Or you're going to drop it to one of the alleged, I haven't seen them yet, I've been actually looking for them, the secured voting drop boxes, ballot drop boxes. They're supposed to be in different places in New Jersey. You can also drop it off at your county board of elections. You can physically take it to your county board of elections, or you can physically take it to your polling place on November 3rd. So, and you can leave it there. You can drop it off there. So the deadline you need to know is that mail-in ballots need to be postmarked by November 3rd. They need to be postmarked by November 3rd. So don't necessarily drop it in the post office, the blue mailbox on November 3rd, or put it in your mailbox on November 3rd, because it may not get postmarked by that time, right? So you want to make sure it's postmarked by November 3rd, and it has to be received by the county board of elections and open and counted if it's a valid ballot by November 10th. Okay. So in other words, the results here in Jersey probably aren't going to be, you're not going to be sitting here watching, your favorite 24-hour news channel on November 3rd, and probably not going to have the results of the election, on the evening of November 3rd, what we're used to. Now, so since everything is by mail-in ballot, and presumptively, and even if you go to vote at the polls on November 3rd, you drop off your mail-in ballot with them, there are certain exceptions to the use of a machine that are specific for individuals with disabilities. So, and it's one of the only exceptions for voting in person by machine. So every polling place that's going to be open has to have a ADA compliant accessible voting machine that allows someone to cast their ballot if they're unable to cast their ballot by a paper ballot this year. So in other words, if you are a person who's blind, or visually impaired, they have machines that you can use that actually read the ballot to you, that allow you to cast your vote, give you an auditory response of what your vote is. I voted for that guy, or I answered yes or no to that public question or whatever. So it gives, has an auditory feedback, okay? So that's one of the primary reasons why polling places have to be open on that day for people with disabilities. There's other people, I can imagine, that don't use a paper ballot or can't use a paper ballot, for which they have the right to vote as well. Now, everyone's vote, if you use a polling machine on November 3rd, is going to be cast as what is known as a provisional ballot. Okay, and that's a legal term of art too. It's a provisional ballot. And what a provisional ballot is, it says, look, we're going to let you vote. We're not sure whether you're supposed to be voting. And provisional ballots have been around for, decades, generations. It's a concept that says, okay, we're not sure you're able to vote. We don't have, we opened up the book and you're not in it this time, and we don't know why, and you don't know why. Your signatures don't match, your addresses don't match, something went wrong. Here, we're going to give you a paper ballot. It's called a provisional ballot. Fill it out, and then we will verify your eligibility to vote because of change of address circumstances or whatever. after the election, and then we will cast your ballot then, as long as everything matches up. The reason why it's cast as a provisional ballot this year, they don't want people voting early and voting often. They don't want me to drop off my ballot on Monday and then walk into the polling place on November 3rd and try to vote again. So it's considered provisional because they're supposed to match up, you know, whether I voted before as to whether I'm voting on November 3rd. Okay. If your person goes to the poll, or if you're a person with disability and you go to the poll on day, and this is true this election, this was true last election, this will be true for all future elections. This is just the state of the law. If you're a person with a disability and you want assistance or you need assistance in casting your ballot, you're entitled to assistance in the polling booth. So oftentimes, and this happens quite a bit, oftentimes, you know, someone goes to the polling place, you know, let's forget that it's COVID, let's forget that it's mail-in ballots. Person goes to the polling place, they have a hard time reading the ballot. They have a hard time understanding. They have a visual impairment, they have a cognitive impairment, and they need some assistance to make sure they cast their ballot in the right way. That person is entitled to someone to help them, whether that's a parent, whether it's a guardian, whether that's a friend, whether it's a staff person at the person's group home or supervised apartment or whatever it might be. The person is entitled to an assistant of their own choosing. Right? And that's just the unequivocal state of the law. I think the only person it cannot be is the shop steward of your union. Like it's some like screwy little exception of what it cannot be. Other than that, you're entitled to a person of your own choosing to assist you. Oftentimes, the person, again, with an obvious disability shows up at the polling place with their mom, and the blue-haired old lady sitting behind the, you know, no offense to blue-haired old ladies, but the person sitting behind the desk at the polling place says, you can't vote, or you can vote, but you can't bring your mom in because, you know, your ballot is private, your vote is, you know, sacred. You can't be influenced by somebody else. You have no, you know, somebody else doesn't have the right to know how you vote. This is simply not true. I generally advise if you're going to the polling place with a child or a loved one, brother, sister, whoever it is, with special needs, particularly if they have an obvious disability, to have the phone number for the County Board of Elections in your cell phone on speed dial, because you may have to be calling them. And I will tell you this, is if you call the Board of Elections, you explain the situation, the blue-haired old lady at the polling place will get a call from the Board of Elections that says, you got to let them vote. Or someone from the Board of Elections will actually come down to the polling place and say, you got to let them vote. My point is don't get pushed around. And don't just walk away thinking that they know, you know, just because there's the one sitting behind the table at the polling place, that they have all the answers and they know everything that's going on. They're usually very good people. They're usually very well-meaning people. A lot of them are very knowledgeable, but not always. And they don't always have all the answers. Remember, there are certain requirements that if you are going to cast a paper ballot and you do need assistance, that the person providing you with the assistance has to also sign the ballot. So on the paper ballots, and this is true with absentee ballots, a good old-fashioned absentee ballot where you request an absentee ballot and it comes back to you. If someone assists you in completing the ballot, all right, this is true if a person, you know, has some physical motor dexterity issues, you know, due to advanced age, you know, maybe needs some assistance due to a cognitive disability. They maybe need some assistance in making sure they complete the ballot the way they want to complete the ballot. They put the little mark in the right circle, and so to speak, and so forth. If a person provides assistance, they have to sign the ballot as well, and they have to put their address. They have to print their name. So you're going to want to, if you're providing assistance to someone, you want to do that. Also, when you put if you put the ballot in the envelope this year, whether it's a mail-in ballot or whether it's the traditional absentee ballot, if the person with the disability is unable or, you know, just doesn't physically take the ballot to the mailbox, or doesn't physically take the ballot to the Board of Elections, or doesn't physically take the ballot to the polling place on November 3rd, but someone is doing it on their behalf. So your child, your son or daughter fills out the ballot, you're taking it to the polling place or you're taking it to the Board of Elections on their behalf. There's a affidavit, there's a blank on the outside of the envelope that's called a bearer's certification or a bearer's affidavit that says, you know, your name, your signature, your address, and you're the person who's dropping the ballot off wherever it's being dropped off at. It's designed to ensure the chain of custody of that ballot, right? That went from the person casting a vote, you know, to their mom or dad, from the mom and dad to the polling place, the Board of Elections, or whatever. Make sure you complete that if that's what you're doing. That is something that is very commonly overlooked. And the Board of Elections will not count your ballot, that ballot, if the bearer's affidavit isn't completed. So there's nothing you can do about it. I mean, that's one of those like bright line rules. There are very few bright line rules in the law, but that's one of them. Okay. So remember that case I talked about before, out of Trent Psychiatric Hospital, there were 5 ballots that, you know, were in controversy. Well, it started out with 7 ballots that were in controversy. 2 ballots got tossed because the bearer's affidavit wasn't completed, and they just got tossed because the technical compliance with the law wasn't met. So, you know, these are like little practical tips and tricks that come up over the years. And it, you know, has nothing to do with necessarily, this year it has everything to do with COVID, and it has everything to do with, you know, controversies surrounding mail-in ballots. But these are issues that have always existed and will exist when things get back to whatever normal looks like down the road. So if you have a child that you're assisting with voting, or they're in a group home and staff is assisting with voting, just make sure that the people who are assisting them do it the right way. Because it really is unfortunate if you're if you go through the trouble of understanding the issues, talking about issues, researching candidates, and casting your vote, and then it ends up not counting. You know, it's very discouraging, and it may have the effect that your son or daughter, your brother, sister, whoever we're talking about here, decides that they're not going to, decides that it's futile to exercise the right to vote in the future. And that's not what we want. You know, people with disabilities really do need to be heard now more than ever before. You know, especially in our current climate, when we're talking about, or have at one point during this whole process, have been talking about the rationing of resources, such as ventilators and vaccines and therapeutics and so forth, and making a judgment call about quality of lives. We're talking about reopening day programs. We're talking about, you know, employment issues. We're talking about people with disabilities who, you know, have borne a disparate amount of the brunt of the unemployment crisis in this country, because people with disabilities are often the first to be, you know, laid off or downsized or whatever. So there's some really important issues, obviously, and more in this election, and in all elections, that really affect folks with disabilities the most. And people with disabilities probably are the most unheard or underheard subgroup or cohort in the American electorate. And that really has to change. You know, people with disabilities and their families really need to make sure they get out there and let their voices be heard. And the most powerful voice that you've got is your right to vote. So in terms of other things that, you know, one other resource I want to share with you before we go is the ARC of New Jersey has some great material on a website, www.gotvnj, get out the vote, nj.org. All right, not, you know, if you go to the wrong one, you might end up on a political party's get out the vote drive. But it's gotvnj, New Jersey.org. And this is information put out by the ARC of New Jersey, including a great little handbook on voting rights for people with disabilities, that also talks about some of the dates that I mentioned before. You know, it actually does a nice job of laying out the 3 public questions on the ballot this year in New Jersey, including one of which is the legalization of marijuana for recreational use, and, you know, other, you know, issues that are, you know, noteworthy. Has a little description about each of the candidates, that are up for election. Remember, in New Jersey this year, we're voting for president. We're voting for one member of the Senate. The incumbent, Cory Booker, is up for re-election, and his challenger. And then all of the members of Congress, United States Congress, are up for election this year. Then, of course, you have some various local officials, municipal elections, school board elections, and things like that are on the ballot, as well as the public question. If you live in Morris County and parts of Somerset County, there is an election for the state Senate to fill a vacancy of a deceased member of the New Jersey State Senate and General Assembly. So, those are all things. This guide gives you some good information that'll talk about the candidates and so forth. So, encourage you to go and go to that website and poke around a little bit and get some more information while you're at it, and some good resources while you're at it. Christina, I don't know. That's all the content I have in terms of substance. We were really about 55 minutes. So if there's any questions, I'll gladly take them now.
So there are no questions. I think you did a good job. One thing I want to address is that the handouts, the ARC handout, we're giving that out at the end, right? Like at the end of the conference, it'll be emailed out to everyone.
Yeah, everybody who signed up for this workshop, that one Get Out the Vote guide that I mentioned, and if there's other materials that folks want, we will email them to the people who registered for this session after the conference is over. Christina is the one who has to email them out, so we're doing this all day today and all day tomorrow. We're going to begrudgingly, we're going to let her have Sunday off. I'm not sure why, and then she'll probably send them out Monday. All right. So, all right, guys. Well, guys, thanks for coming. Thanks for being here today. And again, hope to see you at the keynote. Enjoy the rest of the sessions at the conference. There's some good workshops coming up, and we'll see you down the road. Thanks again, everybody.
Thank you for watching this encore presentation from the Fall 2020 Hinkle, Pryor, and Fisher Parent Empowerment Conference. With 24 other presentations to view, there is plenty of additional information to help you become empowered. As a reminder, the information contained in this video is not a substitute for individual legal advice and does not create an attorney-client relationship. Copyright 2020 Hinkle, Pryor, and Fisher, PC, Attorneys at Law. All rights reserved.